Welcome to Pretty Lies and Alibis. Let's seek the truth and travel the long road to justice together. What you know, Alibuyers, welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. I'm going to spend today catching up on some Donna Adelson documents that have dropped. There are a bunch. So I'm going to break this into two different episodes. We're going to jump in, but first, before we get started, if you're watching on YouTube, you know the drill. Don't forget to hit subscribe if you haven't already. Like the video, share it with your friends, and you can ring my bell if you want notifications of when I post new content. Click that little bell icon. Music fact of the day. What Don Henley classic was originally written for Tom Petty? That would be one of my all-time favorite songs, The Boys of Summer. I have to wish my Grammy a very, very happy 90th birthday. We are having a big party for her on Sunday, but just wanted to say happy birthday to one of the biggest influences, inspirations, and one of the biggest loves of my life. She is amazing. I wish you all could get to know her. There were a lot of new documents dropped in the last few days with Donna Adelson. We're going to chip away at those. On some of these documents, I'm not going to read them word for word. Some of it's just stuff we all know and repetitive and cites case law. I'm just trying to get the meat of these out there so everybody knows what's going on as far as the trial, which is going to be quickly approaching. I mean, we just have a month or so before this kicks off. I know everybody is anticipating it. I'll be live streaming it every day. Let's jump in first with the jury questionnaire. It starts off by saying this questionnaire has been prepared to assist the court and the parties selecting the jury in this case. Please answer each question completely and accurately. Your complete written answers will save a great deal of time for the judge, the lawyers, and for you. Your answers will have the effect of a statement given to the court under oath. Please fill in your answers completely. Since we need to make copies, do not write on the back of any page. If you need more room, continue at the bottom or side of the page or on the last page, noting question number. Please complete this questionnaire by yourself and do not consult with anyone else or discuss the questions or your answers with anyone. If you need assistance to complete the questionnaire, please notify court personnel. Your very best honest effort to answer the questions is needed. There are no right or wrong answers to any of the questions. Please answer thoughtfully, thoroughly, and candidly. At the top, full name and juror number. You are being considered as a potential juror in the case of State of Florida versus Donna Adelson. This case involves the murder of Dan Markell in July of 2014, who was shot in his car at his home in Tallahassee. Mr. Markell was a professor at Florida State University College of Law. He was the former son-in-law of Donna Adelson. 4 people have either pled guilty or been convicted for the murder of Professor Markell, including Charles Adelson, Donna Adelson's son. Donna Adelson has been charged with murder in the first degree, conspiracy to commit murder, and solicitation to commit murder. She has pled not guilty to these charges. There has been media attention to the events surrounding this case. There is nothing wrong with having seen, read, heard about, talked about, or having formed opinions about the case. We simply need to know what your knowledge and opinions are. Please answer the following questions thoughtfully, completely, and candidly. Number 1, how would you describe the amount of media coverage you have seen about this case or the defendant, Donna Adelson? And there are 5 options. A great deal, followed it very closely, quite a bit, read many articles or watched television accounts, a moderate amount, just basic coverage in the news, little, basically just heard about it, and none, have not heard of case before today. Number 2, has your information about this case or the defendant, Donna Adelson, come from, and it says check all that apply, newspapers, including newspapers website, and then it has which with a question mark. Print, periodicals, magazines, which. Television or radio, what shows. podcast, then it has which, social media, including Facebook, Twitter, etc., websites other than online newspapers or magazines, which, hearing people talk about it, personal knowledge or other. If you checked personal knowledge or other, please explain. Number 3, what have you seen, heard, or read about this case and Donna Adelson? Number 4, what are your thoughts and opinions about this case and Donna Adelson? Number 5, have you had conversations with others about this case, yes or no? If yes, A, what have others said in conversation about the case and Donna Adelson? B, what have you said in conversation about the case and Donna Adelson? Number 6, have you done any online research on this case since you received your jury summons, yes or no? If yes, please describe the research you have conducted. Number 7, do you listen to any true crime YouTube podcasts, channels, or programs? If so, which ones? Number 8, what did you think or feel when you received your jury summons for this case? Number 9, to the best of your recollection, what kind of things did you say to others or did others say to you regarding your possible jury service in this case? Number 10, as a result of what you have seen or read in the news media or what you have learned or already know about the case from any source, have you formed an opinion? A, that Donna Adelson is guilty. There's check boxes for yes, no, and unsure. Or B, that Donna Adelson is not guilty. Also, the same check boxes there. Number 10, if you have commented on this or any related case in any form of media, in an online comment or post, or if you have shared a post, please describe. Then below that, I swear or affirm that the answers given are true and correct. Let's move into one of the filings. This one is regarding Luis Rivera. The state is asking that his prior bad acts and also the fact that he is in a gang not come in during Donna's trial. They say they believe defense counsel will bring this up on cross examination. In the filing, it says it's irrelevant, it's more prejudicial than probative, and improper character evidence. It's not a material fact in this case, and it doesn't lend to motive or intent. They note the sentence that Rivera is serving concurrently with the sentence for Dan's murder was gang affiliated. That was also a federal case, which is not relevant to Donna's case. Regarding Rivera's mental health, they say during depositions, he was asked about his current and past mental health, and at no time during the investigation and past proceedings was there any indication Rivera was suffering from any mental health disorders at the time of the murder. If such evidence did exist, it should be excluded as both irrelevant and impermissible character evidence without a nexus between his symptoms and his ability to testify completely. In this filing, they're also asking that investigator Jason Newland be exempt from sequestration. Now, Rivera and his girlfriend, Jessica Rodriguez, are both expected to testify at Donna's trial. There's been allegations of domestic violence committed by Rivera, but that allegation was recanted when Jessica met with prosecutors to discuss the violence. In a deposition on February 15th, 2019, prior defense counsel asked her about Rivera smothering her into a couch. The defense asked if when she met with the state, she said she didn't want to prosecute. Jessica said her exact words to Rivera was, "I will never. You will not go to jail on my hands." When asked by defense counsel if she said she was never hit by Rivera, she didn't remember if she told prosecutors that. The state says that to introduce this would be to taint the jury and also mention her recanting would be an attempt to impeach her credibility and propensity for truthfulness. They move on to they're bringing in 25 headsets for the jury, the parties, and the court reporter to hear all the audio they plan to bring in. They're also bringing in the Dolce Vita recording They have a demonstrative aid as well as clarified audio and a transcript that they want the jury to be able to use to help them follow along. They have the same for wiretap recordings that are going to come in. There's a section called Statements to Elicit Sympathy for Defendant. Defense asked for bond and listed conditions Donna was enduring while being held in the Leon County Jail detention facility. This is irrelevant, and while sympathy and compassion are earnest sentiments, they're not deemed proper elements of counsel's argument to the jury, and it's improper for the defense to appeal to the sympathy of the jury directly or indirectly. The circumstances surrounding her incarceration are irrelevant. There is a defense motion to suppress evidence derived from wiretap interceptions. In the filing, they say they fully appreciate the court denied a similar request with Charlie's trial, and they acknowledge it's unlikely to revisit this ruling for Donna. It says, we believe strongly that federal and Florida constitutional and statutory baselines were not met, stating with the fact that the original April 7th wiretap applications were based on state information and events, the overwhelming majority of which occurred 2 years earlier and therefore failed to establish probable cause. Additionally, the state failed to show necessity, failing to exhaust far less intrusive investigative techniques at its disposal before resorting to wiretaps. Suppression of the illegally obtained wiretap communications and illicit fruits is therefore appropriate. We file this motion if not for more than to preserve the record. They go through the history of the process to get those wiretaps, and they cite Florida statutes saying that aggrieved persons in trial may move to suppress the contents of any intercepted wire, oral, or electronic communication on the grounds that, among other things, the communication was unlawfully intercepted. The information contained in the original wiretap application was stale and therefore did not support probable cause for the interceptions. They cite the Fourth Amendment, which protects individuals from unreasonable government searches. It strictly limits the government's use of wiretaps to record private conversations. The state's probable cause showing for the original wiretap application was premised largely on discrete events to the extent they took place months or even years before the applications were submitted and the interceptions authorized. The applications and probable cause affidavit focused primarily on alleged activities leading up to and the immediate aftermath of the July 2014 murder, as well as events that long preceded it, including the divorce proceedings between Wendy and Professor Markell, which commenced September 2012. Beyond that, the original wiretap application alleged in October 2014 that Katie underwent breast enhancement surgery, that in December 2014, Garcia posted a photo on social media of him and Rivera on motorcycles, that in May 2015, Rivera spoke with the mother of his child and Katie's close friend by phone from federal prison and instructed her to ask Katie for money for bail in his federal case because Katie had the money. In another of Rivera's calls in June 2015, he mentioned the price of the motorcycle he bought the year before. In July 2015, Wendy changed her children's names. And in September 2015, Katie began driving a 2001 Lexus, once registered to Donna's husband, Harvey. And in January of 2016, the title was transferred to Katie. Those allegations were equally stale, reflecting on conduct well beyond Florida's Supreme Court's 30-day guideline. The state will likely argue that staleness should be examined more liberally in this case because the original wiretap applications alleged an ongoing conduct reflective of a continuing murder conspiracy and or that certain communications from Charlie and Katie's cell phones within 30 days of the intercept authorizes sufficiently corroborated the applicant's otherwise stale information. Neither argument has merit. They go on to say to start, this case, an alleged murder for hire, is readily distinguishable from those instances, narcotics and gambling conspiracies, chief among them, where courts have allowed dated information to support a wiretap application. Those cases typically involve long-standing criminal enterprises where there is a strong likelihood of ongoing criminal activity. Here, by contrast, there was nothing in the original wiretap applications to suggest any ongoing criminal activity at or near the time those applications were submitted and the intercepts authorized. The state may point to cash deposits made by Katie's bank accounts between the time of the murder and November 2015, the vast majority of which were made, according to the applications, between July 2014 and July 2015. And Katie's receipt of paychecks from the Adelson Institute between September 14th and January 2016, when she was also employed by a dermatology office. But that information in itself stale, with the activity alleged in the original wiretap applications terminating at most 3 to 5 months before the intercepts were authorized. What's more, these allegations, considered alongside the remaining allegations in the original wiretap applications, do not establish probable cause to believe that a continuing murder conspiracy existed, let alone that communications concerning that conspiracy would be obtained through the intercepts, or that facilitates from which the communications would be intercepted were being used in connection with the conspiracy. The applications presume that the paychecks from the Adelson Institute and cash deposits to Katie's accounts were payment for the murder. But just because the applications allege it doesn't make it so. Critically, there was nothing in the applications to suggest when Katie acquired the cash she deposited, where the cash came from, that it even came from a single source, or that it came from Charles Adelson or any Adelson family member for that matter. This failure becomes especially glaring when it comes to the deposits made in late 2015, closer to the time applications were filed. And as to the payments Katie received from the Adelson Institute, all the applications can muster is that Katie's cell data is inconsistent with her being physically present during work hours. While these allegations may give rise to a suspicion that the murder conspiracy was ongoing, mere suspicion is insufficient to authorize issuance of a wiretap order. The state may also cite to pen register/toll records referenced in the original wiretap applications, which reflect thousands of communications beginning May 1st, 2014, between Charles Adelson's cell phone and those associated with Donna Adelson, Harvey Adelson, and Katie Magbanawa, a small portion of which, 54 with Donna Adelson, 17 with Harvey, and 34 with Katie, occurred within 30 days of the application's submission. For Katie's part, the applications reflect thousands of communications beginning May 1st, 2014, with not only Charles Adelson, but with Sigfredo Garcia and Jessica Rodriguez, some of within the last 30 days. In that, 55 with Charles Adelson, 696 with Garcia, and 5 with Rodriguez. But these communications do not give rise to probable cause for two reasons. First, the original wiretap applications do not reflect the substance of any of those communications, not even text messages, which we understand the state may have possessed by the time the applications were submitted and intercepts authorized. Second, the cell phones that Charles Adelson and Katie Magbanawa connected with the most belonged to individuals with whom they were, at various points, the closest. For Charles Adelson, that meant his mother, his father, and his one-time girlfriend, Katie Magbanawa. For Magbanawa, it meant Charles Adelson and Garcia, her on-again, off-again boyfriend and the father of her two children, and Rodriguez, one of her closest friends. It is therefore unsurprising that Charles Adelson's and Magbanawa's cell phones communicated with those numbers frequently or within 30 days of the original warrant applications. For all these reasons, the original wiretap applications fell well short of establishing what Florida law requires. Probable cause at the time the original authorization orders issued to believe that communications concerning a murder conspiracy will be obtained through the interception and that the facilities from which the communications will be intercepted are being or will be used in connection with that conspiracy. They go on to say there was less intrusive procedures to investigate before resorting to wiretapping. The original wiretap applications all but conceded as much. In the same breath that the applications dismissed the prospect of undercover activities as difficult and dangerous, they also noted, a bit less clearly that they should have, that law enforcement had plans to employ in short order a covert operation using an undercover FBI agent in the hopes of generating chatter among alleged co conspirators. That operation, known as the Bump, took place on April 19th, 2016, just 12 days after the applications were filed, with preparations including surveillance beginning days before. While the applications claimed that this undercover operation could not succeed without an accompanying wire, they offered no explanation for why that would be true or why other, less invasive techniques like surveillance and pen registers used in conjunction with the bump would not suffice. So, what is a pen register? That is a device or program that records outgoing signals from a phone or computer, such as the numbers dialed or the IP addresses that are contacted. It's used by law enforcement as a more advanced version of an outgoing call log, but it doesn't include the content of the communications. Indeed, when it came to surveillance, the applications acknowledged that law enforcement had only conducted surveillance of Katie and Sigfredo on several occasions up to that point. The applications dismissed the prospect of future surveillance out of hand, claiming it would only produce results identical to those already achieved. The applications made no effort to consider the prospect of surveillance of Charles Adelson, Donna Adelson, or other members of their family, either in isolation or as part of its undercover operation, or to explain why such surveillance would necessarily fail. Undercover operations and pen registers aside, while the application purport to explain why other traditional investigative techniques were no longer feasible, their explanations cannot withstand scrutiny. For example, the applications claim that further interview requests and subpoenas would prematurely expose and therefore compromise the state's investigation. But that was not a meaningful concern because the investigation's targets were already well aware of its existence. By its own account, law enforcement had already interviewed Wendy Adelson, during which she was asked to detail questions about her brother and parents, and asked to interview Donna and Harvey Adelson at Professor Markel's memorial service in July 2014. Current and former friends of Wendy Adelson were interviewed in the weeks and months that followed the murder. And in July 2015, the Tallahassee Police Department released a photo of the Prius used by Rivera and Garcia in connection with the murder. As a result, any suggestion that the investigation was somehow unknown to its targets or that further interviews or subpoenas would expose it prematurely rings hollow. So, too, does the application's claim that attempts to interview Rivera and Magbanawa would have proven too dangerous given Rivera's role as local head of the Latin Kings and Katie's association with some of its members. The application offers no explanation for why which that would be true, given the state's insistence that Markel's murder was unrelated to any gang activity. And for his part, Rivera was already incarcerated when the applications were submitted, greatly reducing any danger to law enforcement seeking to interview him. And with hindsight, we know that had law enforcement even attempted to speak with Rivera, it would not have been fruitful, as the applications suggest, given Rivera ultimately agreed to cooperate. The original wiretap applications also dismissed the usefulness of additional search warrants, claiming there was no place left to search. But the applications failed to mention that search warrants were never executed on Charles Adelson's or Magbanowa's cell phones or on their respective residences, and offered no reason why. If the murder for hire scheme was continuing as the state claims, such warrants would not have been useful if only they had been tried. Putting aside for the moment whether traditional law enforcement techniques were unlikely to succeed, the original wiretap applications failed to meet the necessity requirement for another, equally compelling reason. According to the state, these same techniques had already yielded sufficient information to commence a murder prosecution. Specifically, the probable cause affidavit alleged there was probable cause to believe that Garcia and Rivera were hired by Magbanowa and Charles Adelson to murder Professor Markel. The statement demonstrates that the state felt it had what it needed to bring charges against at least those four, and that request to place wiretaps on Charles and Katie's cell phones, therefore, could not satisfy the necessary requirement. So that's a big word salad. There's a lot going on there, but you can see they want to keep those wiretaps out, but they also acknowledge in the very beginning that was denied in Charlie's trial, and this is really just to put on the record. The next motion we're going to go through before we end this episode is the defense motion to move this trial into a smaller courtroom. Let's break that one down. Ms. Adelson's upcoming trial is scheduled to proceed not in this court's regularly assigned courtroom, but in courtroom 3G, which, as the larger of the two, can accommodate more members of the public in its gallery. The decision to use courtroom 3G was, we imagine, a response to the public's demonstrated interest in this case and in keeping with the Florida Supreme Court's position that the public should generally have unrestricted access to all judicial proceedings. As the Supreme Court has made clear, however, the public's right to access is not absolute, but must yield in order to protect a defendant in a criminal prosecution from inherently prejudicial influences which threaten the fairness of his trial and constitutional rights. Where a defendant's right to a fair trial conflicts with the public's right of access, it is the right of access which must yield. Unfortunately, as we learned during Charles Adelson's trial, in highly publicized cases like this one, the more observers there are in the gallery on any given day, the greater the risk to a defendant's constitutional rights. In Mr. Adelson's case, for example, someone in the gallery took a photograph of a note passed between Mr. Adelson and his counsel on the second day of jury selection and proceeded to post that note on social media. While the substance of the note was unrelated to Mr. Adelson's case, the reporting in the media speculated about the note and its importance. Moreover, the fact that it was photographed and released for public consumption forced defense counsel to modify how and when they communicated with Mr. Adelson for the duration of his trial. Even more significantly, later in the proceedings, during cross-examination of an important government witness, one of the jurors stood up in the middle of the examination and signaled to the court to stop the proceedings. After the court spoke with the juror, we came to learn that individuals in the gallery were making facial and hand gestures towards the jury in an effort to convey opinions of the testimony, which were distracting at least to one juror who complained of the incident. Actions like this may clearly affect the juror's ability to independently assess the testimony and thereby affect a defendant's right to a fair and impartial trial. At several points, the proceedings were interrupted when members of the public, contrary to this court's clear admonition, admitted to record the proceedings and failed to silence their cell phones. In a case with tremendous attention and strong opinions that is covered virtually every single day in all sorts of social media and other media outlets, there is a risk of a larger live audience creating a sort of mob mentality in regards to reactions to testimony. By limiting the size of the audience, this court limits the probability of emotional outbursts and reactions in the gallery. Simply put, a larger gallery audience elicits larger responses to the testimony and thereby a larger chance of influencing the jury. All of these types of incidents described above, should they occur during Mrs. Adelson's trial, will threaten her ability to secure a fair trial and risk a mistrial, which no one wants. While Your Honor certainly does his best, the easiest way to mitigate these risks is to reduce the number of in person courtroom observers, which this court can readily achieve by ordering trial be held in courtroom 3B. To be clear, we are not asking this court to prohibit the public's access to Mrs. Adelson's trial or to not respect and adhere to the public's right to have access to the judicial proceeding. Indeed, members of the public will still be able to attend trial, just as they would in courtroom 3G. The courtroom will still have a live camera feed, so for anyone unable to attend in person, Ms. Adelson's trial will be televised on a national network. And as you are aware, many of your trials are routinely held in courtroom 3B, and none of those cases violate the Florida sunshine laws of the public's right to access. On a separate note, courtroom 3G, as it is currently configured, also creates logistical issues for defense counsel that do not exist in courtroom 3B. Among other things, it is virtually impossible for a defendant or her counsel to see all of the jurors while seated at counsel table. Further, the lectern's placement immediately to the right of the state makes it difficult for defense counsel to use the Elmo or other electronic devices during examinations and makes it difficult for counsel to see all the jurors while the examination is occurring. Moreover, the gallery is in direct view of the jurors while examinations are occurring, which can cause attempted influences from the public, which should not be allowed in the trial. All of these concerns are not as prevalent in courtroom 3B. We know that Your Honor has and will do his best to ensure decorum in your courtroom, but there is only so much you can do, especially in a case with as much coverage and public interest and emotion as this one. We are simply asking the court, in the exercise of its authority, to control the conduct of the proceedings before it, to protect the one person whose rights are paramount and whose life is on the line here, and convene Miss Adelson's trial in courtroom 3B. I spoke with court staff yesterday and confirmed they are not having any assigned media seats in the courtroom. There will be a media room, but they did note this is going to be a very heavily attended trial, so nothing's guaranteed as far as your seat in there, which may affect my decision to go down there. It's about an 8-hour drive for me, and then you have to pay for hotels and all that with no guarantee you're going to get in, or maybe you're going to a media room. For me, it's just easier to watch at home where I can see everything and it's quiet. So we'll see. If the judge doesn't grant this request to move it to the smaller courtroom, I'll probably go down and try to get in a few days. On the next episode, we're going to go through some more of these filings, including Donna's attorney wanting to leave out the fact that Donna was fleeing to Vietnam. We're going to read that whole thing. All right, guys. Hope you guys have a good rest of your afternoon. We'll see you again later today for the second episode.